Hey, how's it going?
I had a question about section 83.
Yeah.
I remember you talked about how in 83 say May.
Yes.
Is there really a case where the court would find an unreasonable practice trade and still choose to enforce?
Unlikely, but possible.
It's possible.
Generally speaking, they will. I mean, the case. If you look at the cases just take reason. But the point is that they retain the discretion.
Yeah.
So the question is then, I guess would they ever? But we don't know. But from the cases we looked at, certainly it seems the modification is there. Sorry. Sorry, I'm just trying to get the lights on this. That'll have to do. I don't think I can get it any brighter. Okay. All right. Welcome, everyone. Now, a couple of things. So today is obviously our last lecture before the break, so you will have a good 2-week break. When I came here and started teaching at University of Auckland, I was gobsmacked that you have a 2-week break, because I only had a 1-week break in the middle of my semesters, and so that was, to me, that's a real luxury. So I would really encourage you to maximize and utilize that time well, to ensure you have a grasp of the material from this semester, but also semester 1, okay? Because really, when we get back from the break, you will really be on the home run towards the final exam. Obviously, take the time you need to finish your second assignment or essay, but really, I would maximize this 2-week non-teaching period. So just in terms of how admin-wise it's going to work in the second half of the semester, I just wanted to highlight a couple of things. One is that I will move back to having office hours. I think it's a bit more workable that way, just in terms of the imposition on my time of organizing meetings and things. I've had lots of good consultations, and that's been great. But I will move back to office hours. So I'll have 2 on Wednesdays and Friday, and that will be in my office. So come to my office, first come, first served. Maximum 2 per time. I say that because I have had situations in the past where groups of 3 or 4 have wanted to come and talk to me at the same time, and that's fantastic. But my office just doesn't have the space. So 2 of you at a time. Wait outside respectfully. Let's focus on the course content. I'm very happy to chat careers. If you want to chat careers, you can email me. We can potentially make a separate time, but I'm just letting you know that there are quite a lot of impositions on my time in the second half of the semester. When I'm not teaching, then I have a lot of other things as well, not to mention I have another course. So I have cumulatively 550 students that I'm sort of stewarding through the semester. And all that to say that I'm happy to chat, but we may need to put that forward to, put that back to after the exam is released. So, but if you'd like to talk careers, then you can email me. Please come prepared with questions. I think that's useful. So if you've got a list of questions, and I think everybody who's seen me generally has been pretty prepared. But just to sort of clarify expectations, door open is something I usually didn't think I'd have to clarify, but students will come in usually. Oh, should I shut the door? And I'll say no, just leave it open. So let's just avoid that 30 seconds, right? So doors open for all meetings. That's a flat policy. So you can just come in, we'll have a chat, and then you're free to leave. And I should also say, just be cognizant that you aren't the only student, all right? So let's chat, and then let's let other students come through, and wait in the line respectfully outside. I'll do my best to engage you all. So that's just how that's going to work. I think it'll save all of us time, and it'll focus your revision as well, because you'll be like, okay, I've got a limited time. I've really got to go bang, bang, bang. What are the key things that I need to know? Obviously, as well, the second half of the semester, Marcus is going to be teaching the bulk of that. I'll be teaching 1 week in week 8, misrepresentation, and I'm going to frame that almost as an introduction to Marcus's mistake sections, because I think that, or both of us think that misrepresentation and mistake are very, very similar. So I'll do my best to frame that. Lastly, by way of admin, don't email me for extensions for the essay. Not because I'm, mean. That's not within my purview. We don't. Course directors don't handle that directly. There is an extensions team and there's a process for that. So you need to follow that process, and I will probably not respond to that email if you ask me for an extension, because otherwise I'll be responding to lots and lots of emails. So that's just by admin for admin-wise. If you do have anything you need to clarify, you think you need clarification on about the assignment, you can email me. If it is necessary, I will put an announcement on Canvas, okay? So that everybody gets the benefit of the clarification, all right? But generally speaking, I'm not going to be talking to the substance of the assignment. That's what's being assessed. So that's just by way of admin. Any questions on any of that? All good? Or so far on that? Cool. Well, I'm hoping that we have some really good discussions, and yeah, looking forward to that. All right. Now, just very briefly, we roughly finished on the guarantee principles. They're called suretyship principles, but really it's about guarantees. And it's about those three-way relationships where one party exercises undue influence on the other to get that party to provide a loan or a guarantee for a loan. Normally, the family home or something like that, right? And these principles are essentially about what does the bank or the lender have to do to ensure that if there's a finding of undue influence here, right, that their guarantee is still preserved. What do they have to do? So when you read the principles, what you'll see is that, and these are all drawn from Ettridge, by the way, so it's not like they're not plucked out of thin air. They're summarized helpfully in the textbook, but they're drawn from Ettridge. And it's basically this idea of whether or not the undue influence is imputed to the bank, right? Are they infected with the undue influence that has occurred? And so I'm not going to go through these. You can read them in your own time. But the general gist is the bank must take reasonable steps to ensure that they're satisfied this is not a transaction procured by undue influence. That is, that the person who's providing the guarantee is doing so of their own free will, fully informed of the relevant facts, and has been independently advised as such. Okay, that's the general gist when you read it. Now, I just wanted to highlight rule or the summary section E or paragraph E, where it talks about you do need independent. Generally speaking, you're going to need independent advice. And the bank needs to talk to the guarantor, parents, grandparents, to assure themselves that they've actually understood that the solicitor is acting for them and not for the person who's receiving the loan. Okay, so that principle says the solicitor can normally act for the principal debtor or the bank as well, which is probably a reflection of perhaps a certain exception within UK regulatory frameworks for lawyers. In New Zealand, there are very high thresholds for when a solicitor can act for another party in the same transaction. Generally speaking, you cannot. And you will learn that in legal ethics. You haven't done that yet, but when you do legal ethics, you will learn that it's a very serious thing to act for multiple parties in a transaction. It most often goes wrong. And the reason it goes wrong is because the interests of the two parties will diverge. And a solicitor must always act in the best interests of their client. So that's really, that's just a sort of a divergence in a way, right? That usually, and the bank will say, okay, we're sending you to an independent lawyer, the guarantor, to ensure that you have been told everything that you need to be about this transaction and you're entering it of your own free will. So that's really what the gist of this is. And if they've discharged that obligation, then they will still be able to protect the guarantee if undue influence is found. That is, they can still sell the family home if the child, for example, defaults on the loan, if they've discharged their obligation to ensure they're satisfied that this was procured by, not procured by undue influence. But if they haven't discharged that duty, then they are at risk of the court saying your guarantee is also wiped out. You can't enforce that as against the parents, and therefore you have to, in practice it means that you have to go after them directly. for failing to repay the loan. You know, bankruptcy proceedings or things like that. You can't go after the parents who provided you a guarantee for the loan. So that's just how it works in the case of guarantees. A very common, sadly, situation where elderly parents, grandparents, uncles, aunties, etc. will place trust in a child or a younger person who will say that I just need this money for a particular loan that I can't get or that I can't get by myself, and you know, the guarantee is provided, and then the question is, can the bank repossess that? So this is just a way that the law has developed to protect the parents, the ones who have been unduly influenced, to say that if we're going to, you know, enforce the guarantee against you, we really need to be sure that you entered into it of your own volition without sort of placing undue burden on the bank. So that's just the guarantee principles. And this is the summary. You can read it in your own time. I needed to mention that the effect of an undue influence finding is that the contract can be set aside. It's voidable, and the court can make an order restoring the parties as to where they were, right? Affirmation and third-party purchaser are the two exceptions to that, right? So if there's affirmation, then you can't do that, and you can't set it aside as against a third party. And that really links to this idea of the bank. The bank in this case is the third party, right? They are the ones. And so if they had notice of the undue influence, right? If they're treated as having notice, then it can the contract can be set aside as against them. But if there's no notice, i.e., they have discharged their obligation to ensure it's procured not by undue influence, then the transaction the contract can still stand. So that's really the effect of undue influence. All right. Now, what we'll do is we'll move on to unconscionable conduct, right? I'll give you the roadmap, and then we'll come back to. We'll see how Fa'agutu illustrates that, both of those causes of action. And then, if we have time, we'll do a scenario, but if not, I'll put up a couple of scenarios for you to work on in your own time. Any questions about undue influence from either today or from Monday before we move on? Awesome. Now, let's go to unconscionable conduct, which I think is my favorite cause of action in contract law. So now, again, this is a cause of action that is developed over time, right? And so what you're going to have is multiple articulations of what the legal requirements are. And so I put up things like Hart and O'Connor from the Privy Council to sort of give you a sense again of what kind of behavior it's covering. But unconscionable conduct, in a layperson's terms, is simply about where one party either manipulates or receives the benefit, manipulates one party or passively receives the benefit of a really inappropriate contract, like inappropriately imbalanced contract. And so there will be an overlap often between undue influence and unconscionable conduct, right? Where that overlap is not entirely clear, as we'll see in Fa'agutu, but generally speaking, that they have distinct tests. So we're gonna very briefly go through them. So with unconscionable conduct, you have three things that you need to be aware of. I might just put this up a bit. Sorry. There we go. That'll do. All right. So you've got three things that you need to prove. Okay. One, you need to prove that the victim had a significant disadvantage or disability. And then you need knowledge of that significant disadvantage or disability by the stronger party. Okay, so 1, significant disadvantage, 2, knowledge, and 3, you need the stronger party to take advantage of that disability in terms of the contract. If those 3 things are made out right, what you then get is similar to undue influence, the presumed undue influence. What you get is a presumption which needs to be rebutted. So again, it's similar to this idea of having to show that the contract was indeed appropriate. You know, they entered into it not under the influence of their disadvantage or disability. They were able to think, they were able to reason, all of those things. So it's a factual rebuttal. And if that can't be shown, then there will be a finding of unconscionable conduct. Which will entitle the court to set aside that contract, similar to undue influence. So if they can rebut it, then it's enforceable. So that's the roadmap. That's what you apply to any fact scenario that you see for unconscionable conduct. That comes from Gustav. So Gustav sets out the elements of unconscionable conduct in New Zealand today. The Court of Appeals said it. They said these elements are not exhaustive, but are sufficient for the purposes of the case. For our purposes, we can treat them, and they have been treated in subsequent case law as sort of stating the law, right? So we can use that, and that really can be divided into three things. Really, you need to show disadvantage, disability, knowledge, and taking advantage, exploitation. So let's talk about what all 3 of those things mean, all right? Now, the first thing to note about the first point is that it must be a significant disadvantage or disability. Okay, so it's not just any disadvantage, any disability. It must be of a sufficiently important or weighty threshold to justify the court getting involved. Because note that what the court said in Gustav is the equitable jurisdiction of the court is not intended to relieve parties from hard bargains or to save the foolish from their foolishness. So again, this is the protection of contractual freedom. If you make a bad bargain, the court will not save you from that unless you have been exploited. Your disability or disadvantage is taken advantage of to such a degree that the court must get involved. So it must be significant, number 1, right? And number 2, it must diminish your capacity significantly to assess your best interests. So how can you tell something meets the criteria if it significantly diminishes your capacity to assess your best interests? Okay? I do apologize for my pretty appalling handwriting. My wife always writes in our cards that we give to people because she's like, you don't write, I will write. So I'm like, that's fine if you want to do that. But I hope it's broadly readable. So the third thing to note is that what kind of stuff goes in there, right? If it's significant and it diminishes the capacity, the answer is it's an open category. So it's open to you to argue on the facts that there was a particular disadvantage or disability. You don't have to fit it into particular categories, right? So the court has given us some guidance, what may be a disadvantage or disability. Ignorance, which is interesting, right? Why would ignorance preclude you from being bound to a contract? Right? The court has said that. Lack of education, again, why should that, why should that allow you to escape a contract? But then illness, age, mental or physical infirmity, stress or anxiety, all of those things may well qualify. And then the court leaves it open. Other characteristics may also qualify depending on the circumstances of the case. So, if you see any of these examples listed, you can say, look, this exists in this case, and that would strongly suggest that there's a significant disadvantage or disability. You would still have to prove it, though. This is not like the automatic presumption of trust and confidence for undue influence. You still need to show that it was significant enough to diminish that person's capacity to assess their best interests. They couldn't determine what was best for them because of this particular disability or disadvantage. So that's the process. But particularly for these vitiating factor cases, it really does depend on the facts. It has depended on the facts for most of what we've gone through this semester thus far, but it really does depend on the facts for this course of action. And so, again, feel free, you have permission to disagree with your colleagues on your conclusions. Very normal, and different people will apply these principles differently. What matters is you have the roadmap, you stick to what the court has said, and then you apply it to the facts. So it needs to be a significant enough disadvantage. It needs to significantly diminish your capacity to assess your best interests, and it's an open category. Now, the second requirement is knowledge. Okay? So it's not enough that you had a significant disability or disadvantage if the other party did not know about it. You must show that they knew about it. And knowledge, as the court says, can be either the principal or their agent, right? So if there's an agent involved, like someone as an intermediary between the contracting party and the other contracting party, then the knowledge can be if A and B are the contracting parties, right? And B has a significant disadvantage, right? Either A must be taken as knowing, or if there's X in the middle, then X's knowledge can be sufficient, can bind A as to the contract. That's what the court is saying there. But the knowledge can also be actual or constructive. Okay? So that means they either did know in fact about this disadvantage, right? So you can show that they knew by reference to, for example, their internal documents or whatever, emails. But if they should have known about it, that will also suffice. Okay? And the things that will lead or can lead to finding that there was constructive knowledge is set out in that last paragraph there. The substance of a transaction, so a marked imbalance in consideration. Now, here's the court interference, right? Because you don't assess adequacy of consideration to determine whether there is a contract, but you can look at it for the purposes of whether there's constructive knowledge, okay, for unconscionable conduct. Interesting tension. So if something is really imbalanced, consideration-wise, that may suggest that actually they did have constructive knowledge of the disability or the disadvantage. If one party did not have independent advice, the weaker party, that may put the other party on notice, right? And so, again, these are illustrative examples. They're not exhaustive. In other words, you can look at the facts and say there are other facts that suggest they should have known, right? And if that's the case, the stronger party is put on inquiry and treated as if they actually knew. So what that means for our purposes is that it doesn't matter whether they actually knew of it or not. It matters whether they should have. If they knew of it in reality, mention that, but also just mention that, well, in any case, they really should have because, the transaction was particularly bad, the other party didn't receive legal advice. All of those things may be relevant to helping you determine knowledge. And so the court will say, do you know what, you didn't know about it, but you sure didn't inquire, you sure didn't, raise your eyebrows that this was a particularly egregious transaction, all of these things, right? Like you knew they, let's say they didn't speak English or they were kind of, somewhat impaired in some way, like that should have indicated to you that something's awry here, but you didn't do anything about that. So that's what knowledge is, actual or constructive, principal or agent, right? So this is where it's important, I would say, to have pen and paper beside you, so you can draw the diagrams of what the requirements are, but also what's the factual relationships between the parties. Like who's the lender, who's the guarantor, who's the recipient of the loan, all of those things, right? So I think that's going to be particularly beneficial when you're doing scenarios, right? And to the extent that if any such questions may pop up on an exam. But generally speaking as well in practice, if you have these types of cause of actions, and causes of action generally, I do think it's a useful tool to, draw diagrams. All right, so you've got a significant disadvantage and disability. You've got knowledge, right? Lastly, you need to show that the stronger party took advantage of the weaker party. Victimization, as the court says, or exploitation. And again, this comprises both an active exploitation, right? So you actively solicited and abused and took advantage of this person. You essentially, you really pressed on them to sign the contract, and you were essentially a really bad person. And then it also takes into account passively accepting a benefit from a contract. So it's not a defense to say that you just received this. You didn't do anything. They entered into the contract. They offered this, right? And you just passively received it. Okay? And the court in Gustav says, if the circumstances were such that you either did know or you should have known that you needed to say, no, I cannot in all good conscience accept the benefit of this transaction, unless you have full independent advice or at all. Like even if you have advice, there's no way we can enter into this transaction. It's just too bad for you. Like it's way too bad for you. We cannot do this. It's unconscionable. It's egregious. It's manipulative. It's really bad. And so that's the kind of threshold or degree that the court is getting at, to say that, you know what, if you actively took advantage, yes, but if this was the kind of transaction that you knew or should have known, that you should have said, this is, no, there's no way that it's appropriate for us to take the benefit of this contract. So we should have refused, or we should have said, you need to get advice first. If you want to do this contract, you need to get independent advice and confirm to us that you understand, and then we can proceed. Okay? So that's what it means. As long as you enter into the contract effectively, if you receive the benefit of the contract, then you can be on the hook. If it's the type of contract that you really shouldn't have entered into, or you should have asked them to go get advice in the first instance. So if all of these things are shown, then the presumption arises, and you need to, the stronger party will need to rebut and show that the transaction was fair and reasonable. Now, this is fairness and reasonableness in both process and substance. Right. So process is fine, how the contract was entered into. Substance, though, interesting. Because it seems that the court is saying you don't just have to show that they knew what they were entering into. That may well make it fair and reasonable, but there is an element to which you have to say, do you know what? This is not that egregious. It's not that bad, right? And so, again, this is that interference with contractual freedom. Who is the court to assess whether a contract is fair and reasonable, right? Why should the state get involved in two sophisticated parties entering into a bargain? So I just want to keep pressing on that to show you that there are tensions and ambiguities that are not fully resolved. And that's the nature of the law. You'll be a better lawyer when you grasp that those ambiguities continue to exist and flummox even our most esteemed judges. But so that's the thing. You need to show the transaction was fair and reasonable. That the process was fair, but also that it's a kind of a reasonable transaction. It's not that bad. It's understandable in the circumstances. All of those things, right? So you can make the argument from the facts that you think it's fair and reasonable. If you can't do that, then that will be shown to be unconscionable. Now, there are various cases here that I'm not going to go through. You can look at them in your own time. You can see how the principles have been applied. What is a disadvantage or disability? What is knowledge? What is taking advantage of? So that's for you to look at. What I've done is I've given you the framework, right? So if you've got the framework, you can then apply it to the scenarios and the cases. Okay, we'll see how it applies in Whāgutu, but the other cases you can look at. But I want to just say that there are two potential situations, right? Because you may get confused with how undue influence and unconscionable conduct apply. For unconscionable conduct, the first situation, right, is a two-party situation. So A and B enter into a contract, right? And there was unconscionable conduct, right, from A to B. So A exploited B, B had a disadvantage, A took advantage of it, A knew about it or should have known and took advantage of it actively or passively. And there was no rebutting evidence, okay? That's the first situation. The second situation is the three-party situation that we saw with the bank. Okay, now not always the bank, but often a bank or a lender of some sort. So we've got three parties, right? So A exercises some sort of pressure, unconscionable conduct here, so that B will enter a contract with C. Right? Often a guarantee, right? So it's the same situation. And C will often, enter into some sort of ancillary contract with A. Now, with undue influence, the question is, can this be imported to C? Okay? Right? So you're actually analyzing this here, this relationship between A and B for undue influence. For unconscionable conduct, what you're actually doing is you're analyzing the conduct and relationship as between C and B. So you're saying, was it unconscionable for C to take advantage of B? Was there a significant disadvantage or disability? Right? Did C know actual or constructive? And did they take advantage by actively or passively extracting a benefit? So that's the conceptual difference between undue influence and unconscionable conduct in terms of the analysis you apply. Functionally, it will be quite similar because the facts will be quite similar often in the scenarios that you see and the cases. They often involve a guarantor being like the elderly parents, and there's some sort of inappropriate pressure applied by the child, and then the question is, can the bank enforce this contract or this guarantee? And for undue influence, the question is, was there inappropriateness as to the relationship between A and B? Was there trust and confidence? Was there a transaction that called for an explanation? Was there any rebutting evidence? Okay. With unconscionable conduct, you're flipping that and you're going to the relationship between the bank and the guarantor. And you're saying, was it unconscionable for the bank? What did the bank do that was unconscionable? Right? Did they know or should they have known about this disability? And did they take advantage of it if they did know? Quite similar to the guarantee principles, but not exactly the same. So that's kind of where I just wanted to highlight from a process perspective, that's the different emphases of those two causes of action. So that, as I've said there, it's not about whether C is on notice of this, right? The question is it unconscionable for C, the bank, to proceed with the transaction in all the circumstances, right? So that's just I just wanted to sort of clarify that. All right, now I'll quickly go through this one, and then we'll go to Fagutu, because I think that will, actualize these principles. So this is a case where Commonwealth Bank and Amadio, you've got elderly Italian parents. They had very limited education. They had limited English and limited business experience. The son says to them, "Can you help me? I want to increase my company's overdraft to basically be able to draw more money for my company." And his business hadn't been going well. The parents signed the mortgage with the bank for very little discussion, so they guaranteed the loan using their family home. They didn't read the document. The lawyer didn't explain its effect to them. And they were found to believe that their liability would be a maximum of 50,000 Australian dollars and time limited. So that was what they considered they were signing up to, that the guarantee was only as up to $50,000 and it was time limited, because that's what their son told them. So obviously the son's not a great person, right? The company then goes into liquidation, and the issue is, can the bank sell the house? So you've got your classic three-part situation here, right? So the son is here. He's exerted some sort of influence or inappropriateness on the parents. And the question is, can the Commonwealth or Commercial Bank of Australia, can they enforce this contract? And the court says no, that contract, that mortgage needed to be set aside, that guarantee needed to be set aside. It was an unconscionable bargain. Okay, so what was a significant disadvantage? Well, you can look at the age of the parents in their 70s, the lack of education, limited English, limited business experience. All of those would suggest there was enough of a disadvantage or disability to stop them from assessing their best interests. If they can't read the documents, they can't properly understand them, then how are they supposed to assess their best interests? The bank had some knowledge of this, and obviously if you send an agent, like a bank teller or a representative from the bank to someone's house, and these parents are quite elderly and they don't quite speak proper English, the bank employee should know there's something not quite right. And they were therefore obliged to make further inquiries, and it was unfair and unconscientious of the bank to proceed to procure their signatures on the mortgage without such inquiry. So this was the kind of situation where there was a significant disadvantage and disability. They knew enough that they should have known of this, that it would affect their ability to assess their best interests, or that it should have put them on notice, and they took advantage of it by procuring the contract anyway. And it's the kind of contract to say that we can't accept this. Like you need to get independent advice that meets enough of the thresholds for us to know that you're doing this of your own free will and you understand everything. So that's an illustration of the facts. Now, there are plenty of other examples here which you can go through. But did anyone read Fargutu? Anyone want to just give a précis of that for the class? Just a summary of the facts. Just shout out. Yeah, go for it.
This man sold his house he had and put all the money, his life savings, into a term deposit, and it was going to earn interest. And then at the end of when he was coming to the end of his life, he became much more religious and realized that the interest would be going against his religious beliefs, and then wanted to put the money somewhere where he wouldn't be getting interest in a religious compliant way. And then his tax accountant came in and said, there's this agreement where you can give the money to like a young entrepreneur. You take on the risk, and you get a share in the profits of the business.
Yep.
As well.
Absolutely, right? So you've got, that was a great summary. So, and you can see, so this is why I want you to read the cases. So you understand the fact patterns, and then you can understand the sort of reasoning that the courts applied. So that's the facts. You had this elderly man, right, who became quite religious, and he had this very close friend / his tax accountant, right, who's sort of almost like a spiritual mentor as well. Anybody else who read the judgment want to sort of how did the court? What was the issue in terms of the contract that was, procured, and then what did the court say? How did the court approach that?
There were 6 issues in question. The first one was which law governed the contract. Was it Sharia law or New Zealand law?
Yep.
Was it entered into under undue influence? Was there an exercise of undue advantage or unconscionable dealings? Was there a breach of fiduciary duty between parties? And if there wasn't undue influence and there wasn't unconscionable dealings, were the terms of the contract breached? And the last issue was there a breach of duty of care, and there was a claim for tortious deceit?
Yeah. So great, right? So you can see how in one fact matrix there can be so many causes of action. Now, for our purposes, we're not concerned with tortious deceit. We're not that concerned at present with choice of law, though that's an interesting element that will be foundational to contract law disputes. But we can see that this intersects with breach of contract as well, right? So what we are concerned with are the 2 grounds about undue influence and unconscionable dealing / unconscionable conduct. Those are words that the courts use for this broad cause of action. Now let's go back to undue influence. What did the court say about undue influence? How did the court reason there as to whether or not there had been undue influence in the context of this particular investment contract? Yeah.
In terms of finding a special relationship between the 2 parties, they found that it was essentially given that the deceased and Mr. Durramy had that sort of special relationship because A, they'd been friends for about 30 years at that point, and B, Mr. Durramy could tell very obviously that as Mr. Ali was coming to the end of his life, he was becoming much more, mindful of adhering to the Quran's teachings.
Yep.
So he should have known, sort of in that situation, that there was uneven bargaining power. They also found that although technically Ms. Fargutu is in a different situation, that she and Mr. Durramy did not directly have that kind of relationship, she was essentially passively acquiescing to what her husband was deciding because he was the financial person in the relationship. The conclusion that they reached from Mr. Ali ought to be extended to Ms. Fargutu on this ground.
Yeah, and absolutely, right? So what you had, what was the focus of the undue influence part of the judgment? The nature of the relationship, right? So the trust and confidence was there. This is a good illustration of how there's both actual undue influence, right? Right? Because he did take advantage. He did press on Mr. Ali to say, you need to, do all this, you need to invest in this, and you need to, be faithful to your religious beliefs and all of those things. Like, he did actively exploit that relationship. But you can also show that there was clearly a relationship of trust and confidence because they were that close, accountant, but also spiritual advisor, mentor, all of those things. And the transaction did call for an explanation, right? It was quite inappropriate, or at least it was really something that really needed to be, explained. And so Mr. Dahimi couldn't do that. In fact, it was the other way. He was actively arranging the transaction. It wouldn't have taken advantage, wouldn't have happened without his intervention. He personally benefited from it. There was no independent advice as well. So there wasn't a question of he sent Mr. Ali off to get advice. This was simply that. Okay, so this fact matrix illustrates undue influence really, really well. Okay, but this fact matrix also illustrates unconscionable conduct as well, because what you have is the special disadvantage, because it was physical frailty, illness, right, breathlessness, physical infirmity and pain, all of that, and probably allied to his vulnerability, being close to death, like the sort of being under that particular manipulative influence, all of those things, right? And here there was actual knowledge. So there wasn't constructive knowledge. He actively extracted the benefit of the transaction from the couple. He introduced this particular investment scheme or style of investment scheme. And the court distinguished between the fact that he wasn't an intermediary, he was the beneficiary, okay? And it met the threshold of this knowledge was of such that he had to say, look, I can't go ahead unless you've had independent advice that we're certain you are fully and with full information consenting to this. So that this fact matrix illustrates both causes of action. It's really something that I think you should read if you haven't read already. The last thing is they set aside that investment agreement, right? And then they ordered a payment of equitable compensation. I believe it was around $20,000. But that's an illustration of the equitable discretion of the court as to remedies, which by extension applies to undue influence as well. So the difference with duress is that duress, you only get the ability to have the contract declared void, okay? And then the court will make any restitutionary orders necessary. But they're not going to add compensation on top. The court can do that for undue influence and unconscionable conduct. And you wouldn't need to say how much, like you wouldn't need to reason the amount, right? You could put a speculative amount, but you would just need to leave it at that equitable compensation may be available, and you can say it may be appropriate in this particular instance. Okay, good. I think we've covered what we need to cover for unconscionable conduct and undue influence. So given the roadmaps I've given you, go back to the slides and the cases, review them within those matrices, and see how they apply. Okay. I will see you in 2 weeks' time. Have a good break. Oh, by the way, sorry, 30 seconds. If you do need to see me during the break, you can email me. We can try and make a time, though my capacity is limited. So, yeah, otherwise, have a good break. I'll see you in 2 weeks. Yes.
Didn't invest in one of his clients' companies.
Yes.
He didn't take that personal amount.
Yeah.
no unconscionable conduct? Probably because he's not extracting a benefit.
Yeah.
But
So
what about undue influence?
yeah, so it probably is undue influence because the transaction itself would require an explanation.
Yeah.
If he's investing in the client's company, so then it brings into play the third party. So has the third party got any benefit out of it? And then the question would be, have they received notice of that? So that would be the third party protection. Unconscionable conduct, you could potentially bring the action if he indeed didn't get the benefit, then the unconscionable conduct would be like the investor and who essentially the contract was with, like the third party. But yeah, so that would